Good morning, everyone, and welcome to the Brady Cobin Law Group Facebook Live event. My name is Tina Nelson. I am the office manager here at Brady Cobin Law Group, and today we are speaking with board certified specialist in estate planning and probate, attorney Andrew Cobin, the Cobin of the Brady Cobin Law Group. Good morning, Andrew.
Good morning, Tina. So happy to be here for my first Tina talk.
Pretty much.
Yes.
Let's see. Today our topic is irrevocable trust. We will be discussing what is an irrevocable trust. I'm going to mess that up a few times during this, but it's going to be okay. What are the benefits of this type of trust, and how does an irrevocable trust work with a will if you have one already in place? We're going to discuss this and more. First, let's take care of some housekeeping first and foremost. Please note that this Facebook Live event is for informational and educational purposes and is not intended as legal advice. So we're going to get started. And Mr. Cobin, first and foremost, who is Andrew Cobin? Tell us a little bit about yourself.
Such a deep question,
Yes.
Tina. Well, I think first and foremost, I'm father of two young and beautiful children and a lovely wife. I live here in Raleigh. Mm-hmm. When I'm not working, I'm usually spending time with them or doing my passion, which is Brazilian Jiu-Jitsu.
Yes.
So I do a lot of that.
Okay. What made you decide this practice of law?
So prior to moving to Raleigh, I was in the Navy JAG Corps. Mm-hmm. And one of the nice things about the Navy JAG Corps is once you get good at something, about 6 months into an assignment, they say, now you're going to go do something else. So after 7 years of that, I got pretty comfortable with the idea of I can tackle whatever area of law I need to learn. Mm-hmm. And I thought about what my favorite course was in law school, and my favorite course was my Trust and Estates class.
Okay.
And so I did some research and decided this is the area of practice I wanted to go into.
All right. Well, that sounds good. All right. Well, let's get into our discussion. Let's start with the baseline so we can kind of have a first level. What is a trust, first and foremost?
Yeah, great question, because I think there's a lot of misperceptions about this. Mm-hmm. A trust is really just an agreement. It's a contract, right? It's agreement between the people who create the trust and the trustees. Okay. And that agreement is going to govern how the assets under the trust, so the assets titled in the trust, are going to be controlled, administered, managed, etc. Mm-hmm. And in general terms, that it's going to say, use this property for the benefit of the beneficiaries. Okay. So we have this agreement, and there's really three parts to it. There's the party that created the agreement, there's the trustee, mm-hmm. and there's the beneficiary. Okay. Right? But that agreement concerns all, and it governs the assets under trust.
Mm-hmm. Okay, so then what does an irrevocable trust mean, or rather, what is an irrevocable trust?
Great question. So, in terms of the trust just being an agreement, right, depending on how we structure that trust, it's going to produce different results. And sometimes we want those results to be set in stone, more or less. Although there's nothing ever set in stone entirely in the law, right? But we have trusts that are revocable, and we're saying that we're drafting this trust that the party who created it has the power to change the trust or to revoke it. Okay. Right? And that's how that agreement would be structured. Mm-hmm. Or we could structure the agreement to say that the party that created the trust no longer has the power to revoke it. Right? Okay. So we create the trust, same parties, right? But now instead of having the authority to terminate the trust, doesn't rest solely with the party that created the trust.
Okay. Well, that answers my question. What is the difference between an irrevocable and a revocable trust? So what kinds of situations would an irrevocable trust help someone? Like, how does that work? What would be the situations to put it in place?
Yeah, so I think maybe the best way to look at it is we use these revocable trusts primarily as an estate planning tool in order to provide a means to plan for incapacity, a means to transition our wealth and our property at death. Mm-hmm. Okay, so that's a pretty common one. So that's the most common one you're going to find out there. We may have some other needs though that aren't going to be addressed by that revocable trust.
Okay.
So the big ones that we see in our office, one has to do with Medicaid planning, right? So we would use an irrevocable trust in terms of as a tool to plan for long-term care, plan for Medicaid.
Okay.
I know Gretchen and you have talked about that.
Yes.
So if you're out there, you could
jump on
go
that
find
YouTube.
that one. That's right. We also use irrevocable trust a lot for tax planning, and that is primarily estate tax planning, but could also have an income tax element to it as well, income tax planning element as well. So a little bit more advanced, but definitely something that would be the right tool to use in the right circumstance.
Okay. Well, if you're just joining us, maybe a little late, please note that we're speaking with Andrew Cobin again, attorney here at Brady Cobin Law Group, talking about irrevocable trust. Note that this is a Facebook Live event just for educational, informational purposes. It is not, absolutely not intended to replace legal advice. When legal advice, come see Andrew. He'll be more than happy to give you legal advice. Yes. Let's continue. So what are the benefits of an irrevocable trust? We talked about the situations, but what are the benefits of it?
You know, I want to take a second to step back.
Sure.
And address something I didn't before, and that's there's a third type of irrevocable trust, and it's a revocable trust that becomes irrevocable.
Okay.
Right. So remember, we talked about that revocable trust is something we could use as an estate planning tool to transition our assets at death.
Right.
And we could say in that revocable trust, send my assets to my heirs when I die, but instead of giving it to them outright, give it to them in an irrevocable trust. Okay, so that would be a third type, or I guess maybe it's a hybrid of the first type.
Right.
So it's a revocable trust that now becomes irrevocable.
Gotcha.
Okay, so in terms of the benefits, that's the big one, right? For most people out there, when we're doing estate planning, and we're talking about what are your concerns, and if the concerns are, well, I don't want my inheritance to go to an ex-son-in-law or an ex-daughter-in-law, or I don't want my inheritance, my children's inheritance, to go to a creditor in the event of a lawsuit, right? So one of the tools we would use is saying, okay, well, instead of giving to them outright, they're going to receive it now in this irrevocable trust.
Right.
And so if they get sued, if they get divorced, it's a serious impediment to that spouse or that creditor from accessing the inheritance. Okay.
I think I like that one.
That's a good one, yeah. The other ones, sort of, again, on the Medicaid side or on the income and estate tax planning side, well, we're reducing estate taxes, right? Or we're offsetting that liability. We are maybe getting a good income tax deduction by structuring this trust. And obviously the Medicaid one is now you're eligible for Medicaid benefits, or more likely to get eligible for it.
And there's more to those in setting those up as well, especially with the Medicaid one. Again, look at Gretchen's video.
That's right.
Okay. My next question, I'm not sure if we covered this. What different types of irrevocable trusts are available? And there was 3 that we kind of listed. One of them was the Medicaid trust that Gretchen had talked about, but there was 2 other ones.
Yeah, so there are several, right? But I think the big ones, are the ones that we see most commonly here, are something called an irrevocable life insurance trust. And that is a trust that is designed to hold a life insurance policy.
Oh.
And it's an irrevocable trust, and with that we get some estate tax benefits, and I'm sure we can dive into that.
Right.
The other one is a charitable trust, and that's what we would call, kind of the technical term, is a split interest trust. And so it is a trust that's designed to give some assets to charity, an income stream to other people, including the person who created the trust, if that's how it's designed. And with that, you get an estate tax and an income tax benefit usually as well.
Wow. We really need to come see you, because that didn't even know that existed. Okay.
Well, you're not listening closely to my phone call.
No. I don't eavesdrop sometimes. Okay, so let's say we have a will already. We went ahead of the game, and now we want to come back and do an irrevocable trust. How does that work together with my will?
Well, that really depends on how the assets are going to be controlled. In other words, if we have assets inside of our irrevocable trust, that's going to dictate how those assets are controlled,
Right.
or when we die, what happens to those assets, right?
Okay.
When we have assets outside of that trust, that may be directed by a beneficiary designation, like in life insurance or retirement account. It may be an asset that's jointly held with the right of survivorship, so it would go to the other surviving owner at your death. Or it may be governed by the will, right? And so the will would set forth terms that also say, do this with my assets upon my death.
Right.
Send it to these folks.
Okay. Let's talk assets. You brought that up. How does an irrevocable trust protect assets? Can we get into that a little bit?
Yeah, so it's interesting when we meet with clients, we have them fill out a questionnaire, and one of the things we do is we list kind of eight different items that may be of concern. We ask the clients to rank them, and probably about 90% of the time, someone ranks in the top three. I want to protect my assets, and so I go through the questionnaire with the client, and I say, okay, I see you mark this as high importance to you. What does asset protection mean to you? Right, and everyone has a different answer for that.
Right.
For some folks, it's what we discussed, right? That I want to make sure that my heirs receive the inheritance in a form that's protected from their creditors, right? Other folks, a lot of folks are saying, well, I mean that I don't want it to be squandered. I don't want the government to come in and tax it. I don't want the courts to get a hold of it and lock it up.
Right.
Right. So that's what asset protection means to different folks.
Right.
How the trust protects, how an irrevocable trust protects it. Basically, it's saying that, hey, we have beneficiaries of this trust. Right? By and large, the beneficiaries of the trust technically don't own the assets in trust. Right?
Okay.
They get the benefit of the assets in the trust. They may
Right.
get income. They may have access to the principal. Right? But the legal owner is the trustee. So the trustee is the legal owner. The beneficiaries are the beneficial owner. So effectively what the trust does, it divides ownership of assets between legal ownership in the trustee
Right.
and beneficial ownership in the beneficiaries. Right? So if the beneficiary gets sued, for example, right? So let's say they got into a car accident, they got sued, right? And they were unsuccessful in defending that lawsuit. And now the claimant, right, the plaintiff has a judgment. They were successful in court, so they now have a judgment.
Right.
Now they're a creditor because they're
Right.
going to come and collect on that judgment. Well, that judgment is against the beneficiary. It's not against the trust.
Right.
Right. So that's sort of the concept at play here, is that you can't enforce that claim against the trust because it's not the beneficiary doesn't own it.
Right.
These are assets under this agreement, and in terms of that agreement govern, and typically the way that agreement is going to say is that these are for the beneficiary only, not for the beneficiary's creditors.
Right.
Now, all that is to say that nothing's black and white, right? And your mileage on that's going to vary, and some of that's going to depend on what state you live in.
Okay.
Okay. In North Carolina, it's pretty well established, pretty strong laws that those assets aren't available for the creditors.
Okay.
Right? Even if the beneficiary is also the trustee.
Right.
Right. So that works great in terms of estate planning. Where it doesn't work great, and where people would have a tough time if they tried this, would be, I'm going to set up an irrevocable trust. I'm going to name myself the trustee and the beneficiary. I'm going to put my assets into it, and now I have asset protection. That doesn't work in North Carolina.
Okay.
In some jurisdictions that works.
Yeah.
There's certain rules in place for that, but that doesn't work great here.
Okay. That kind of makes sense from your first description. You have to kind of split it, if you will, for it to work.
Yeah, well,
beneficiary and trustee.
Right. So I think that the distinguishing fact there is that if you take your own assets and you put it into an irrevocable trust for your benefit, you haven't really done anything. Right. Right. If you receive assets, right, if you receive them, so they were never yours to begin with, they were gifted to you through an inheritance, what have you. That's different. They were never yours to begin with, so we're going to look at that differently.
Okay, that makes sense. Are there any specific terms that need to be included for the asset protection?
Well, some of this is going to have to do with well, you need a spendthrift clause. That's the technical term of it.
Okay.
But that's the clause that says that these assets are for the beneficiary's use only, not for the beneficiary's creditors. Effectively, is what it's saying. You also might, and again, it's going to depend on the jurisdiction, but you might want to set forth the parameters under which the beneficiary can receive the assets, right? So these are, when I talk to clients, these are kind of the rules for distributions, right? Distributions can be made under these rules. So a common one there is distributions can be made for the beneficiary's health, their education, and maintaining and supporting their lifestyle. Right? So health is pretty clear, and education is pretty clear. Maintenance and support means, okay, would an individual of this level of wealth do X with the money? Right. Right. So is it enough money where it's going to be champagne and caviar every night, or is it going to be more like tuna helper? Right. And if you're in the tuna helper category, well, the champagne and caviar don't qualify as maintenance and support. Okay.
Thought I had something. So, are there any restrictions as to what type of assets can be used to fund an irrevocable trust?
Not restrictions, but ramifications. Okay. So, and typically those ramifications have to do with taxes.
Okay.
So, and the big one is what a lot of folks have. A lot of folks, their wealth is primarily in their real estate and in their 401k or their IRA. And IRAs are actually, they're trusts themselves, believe it or not. So you're the beneficiary of that account that Fidelity or whomever holds as the custodian, right? Okay. So they're managing it for your benefit, and they're also holding it so that when distributions are made to you, right, then it gets reported to the IRS that you have to pay the income tax on it. So if you were to try to, during your lifetime, if you were to try to take that IRA and move that account into the trust,
you're gonna get hit.
You've made a distribution. You've taken everything out of that account. So yeah, you're gonna get hit with the taxes. Okay. And similarly, is that what we do with those assets is we use beneficiary designations. And sometimes quite often, right, we're gonna designate the trust as the beneficiary of the IRA. So upon my death, I don't want my IRA to go to my kids. I want it to go to my kids' irrevocable trust. Right? So, and we have to structure that trust properly so that it complies with the IRS requirements, and also that we've given consideration to what's the tax effect as that money comes out of as the distribution is made out of that IRA to the trust. Okay.
This is good stuff, Andrew. I mean, I work here, but like I said, I don't pay attention. No, I pay attention. No,
I'll note that for your next review.
Exactly. I'm enjoying this information. I hope our audience is enjoying it as well. Again, if you're just joining us, we are speaking with Andrew Cobin, Attorney Cobin of the Brady Cobin Law Group, and we're discussing irrevocable trust. And again, this is just a Facebook Live event for educational and informational purposes only, not for legal advice. I want to make that be sure. We have a couple more questions, a little more time, so if we can get back into it.
Sure.
Let's talk about trustees of an irrevocable trust. Who or how do we choose that person?
Great question. So generally speaking, right, we want a person in that role that's going to be responsible in terms of meeting the requirements of the trust, meeting the requirements of the law, filing taxes on time. Okay. And I think importantly, recognizing when they need to reach out for professional support. Okay. Right, whether that's financial advice or tax advice or legal advice. Right. Okay. That's an important piece because you don't want to have someone in there and set that person up for failure, right? Okay. Because you know that they're a hothead and they're going to say, "Well, this just feels right to me. I'm going to follow my gut." Which I don't know. Maybe that is morally or ethically the right thing to do, but not legally always, right? So sometimes, a lot of times, folks will use a family member, right? But sometimes that's not a great fit. Yeah. Right? Sometimes the trust may be complex enough where you really need to have a professional in there. Okay. Right? So then you're looking at CPAs, attorneys, or even possibly like an institution, like a professional trust institution, like a bank or a trust company.
Okay. Is that something you're willing to do for your clients?
For the right client.
Yeah.
No, just kidding. My business model isn't to try to become everyone's trustee.
Right. No, absolutely.
But sometimes that is the right fit for the client, and we explore that.
Okay.
And I think the important thing there with the client is the disclosures that typically when I'm serving as the trustee, I have my duties as the trustee, but I also have legal support that I need.
Right.
And I'm going to hire my law firm to provide the legal support.
Of course.
So there has to be an understanding that I'm getting paid both ways, right? Through the law firm and through my commission as the trustee. But also, there are not a lot of checks and balances going on.
Okay.
All right. So when I'm the legal advisor to the trustee, I'm watching the trustee to make sure that she's not doing anything improper. And the trustee's watching me to make sure I'm not doing anything improper.
Right.
And so there's that potential conflict when I'm serving in both roles.
Okay.
For the most part, I tell clients, listen, my law license is worth a lot more to me than whatever I could defraud your trust. But yes, that is something that has to be disclosed.
Okay. So you mentioned about the irrevocable trust not being able to be changed, but can it ever be modified? I know we can't just put it away. Can it be modified?
It can.
Okay.
Yeah, it's one of those well, wait a minute, you told me it's irrevocable.
Right.
There are ways to modify it, right? So, revocable, when we say revocable trust, really what we're saying is that, for the most part, the party who created the trust retains the power to revoke it.
Okay.
So we have ways to change an irrevocable trust. It's not going to be solely up to the party who created it.
Okay.
Right, and there are several ways, right? So there are ways through the statute that we could do it. So let's say that the grantor, the party who created the trust, is still alive, and all the beneficiaries of the irrevocable trust are still alive. Well, if everyone consents and agrees that we should change the trust in this way, you can do that privately. You can basically sign a modification to the contract effectively, right? And we can change the irrevocable trust.
Okay.
Outside of that, we may be having to go to a court and looking at other provisions in the statute that allow us to modify a trust. One of those being that, the intended use of this trust is no longer needed. Okay. Right? So an example of that would be, we had these folks that they set up their trust in 1999. Do you know what the estate tax threshold was in 1999?
No, of course not.
Okay. It was about $750,000. So if you died and you gave away more than $750,000, you were paying tax on that amount over $750,000. So what attorneys did is we set up these trusts to kind of alleviate that. Well, then today, as it stands today, do you know what the state tax rate? It's $11.7 million.
Ooh.
Now, that's set to change, right? But that's, a lot of times we have these, and often it's a little old lady, right? Her husband died, and, there's all this money wound up in this trust, and she doesn't understand it. Right? And there's not a tax reason for it anymore, because when they drafted this thing in 1999 and never bothered to update it, the rules have changed.
Okay.
Right? So we can go to the court and say, hey, the purpose of this trust is no longer needed.
Yeah, that makes sense.
Right? So we can modify it. A third way is we can use something called a trust protector. Yeah, this is a little technical. So what a trust protector is a third party that's authorized to make changes to the trust agreement as long as it conforms with the objective of the party who created the trust. Okay, so this is these are provisions that came kind of popular in these offshore trusts, right? You'd have folks would say, I want to have my trust in the Seychelles, right? And so you didn't necessarily want to rely on a Seychelles court to make change to the trust if you needed to. So kind of the attorneys came up with this idea, well, let's give someone power to modify the trust. Right. It won't be me, right, because I created the trust, but we can give this trust protector the power. Okay. So that's a provision typically I include in all my trust agreements, and it just allows it's not taking away the right to go to the court. You always have that option,
Right.
but now we've got greater flexibility.
Okay.
We can now avoid the court entirely
Okay.
in some cases, and so it's just more efficient, more cost effective, easier.
Okay.
Right?
I think I got it. We'll come see you if we don't.
Okay. Sounds good.
So, okay, I'm not a rich person. I mean, my boss pays me well. He's a good guy. But setting up a trust, is it really just for rich people? Because when we hear trust, laymen thinking, well, it's for people who have millions of dollars. Is that true?
It's not true.
Okay.
Right. And I don't think a trust is the right fit for everyone either.
Right.
I do, probably 90% of the clients that come through, we are doing some form of trust planning, just because it's a superior form of planning in terms of giving us additional flexibility if you're incapacitated, an efficient transition of wealth at death, and then setting up asset protection for the heirs.
Okay.
Right. So in that sense, it makes a lot of sense
right.
to go that route, but that's not the case for everyone. So it's not just for rich people, right? It's interesting because everyone's got a different definition of what rich is.
Right.
Right. You talk to someone and they've got a $15 million estate and they say, well, my estate's pretty modest.
Oh, I get that all the time.
And you say, okay, right. Depends on what your definition is, right?
Right.
So the question is it the right tool for the job to meet my objectives, my goals?
Right.
And was there a cost element to that question or no?
Not yet.
Okay.
All right. We'll go to that in a
You
moment.
get that. Okay.
So back to the will.
Yeah.
Right. I have a will. And I, went online. I thought I could do it on Google, which is, we don't recommend that for anyone. But I have this will, and I think I can do a trust myself. Can I do a trust myself?
You sure can. I don't know if it's a great idea. We get that. Pretty regularly, right?
Yeah.
Someone will say, well, can you review these documents for me? I did this online.
Yes.
And you say, okay, so you have a California trust that holds real estate in Florida for someone in North Carolina that you created online.
Correct.
Right. And oh, by the way, when I look at the code in California, it doesn't look like you met the requirements or proper execution of this document. There's a lot of pitfalls.
Yeah.
Right.
Okay.
And I think importantly, just like when most folks come in, they're not aware of the issues.
Yeah.
Right. It's just that they're not aware. They may not have considered the fact that asset protection is something I should be aware of and concerned about.
Right.
Right. So how would you know that if you're just going on whatever, Quicken Wills or whatever to do it? I will say this. In terms of revenue streams for us, right? So we do planning, we do litigation, we do elder law. We do probate. So we help people through that probate process.
Right.
By far, and you can attest to this because you've been involved in them, the most lucrative probates for me have been the ones where someone handwrote their will, or they used some janky thing they found online.
That's right.
And it created all kinds of problems that these simply did not foresee.
Yeah, absolutely. And that brings me to our best question that we always get is, how much would this cost?
Yeah.
How much would a irrevocable trust cost?
I'm going to give you the answer. It depends. Okay, and it depends on a lot of different factors. I think, by and large, right, and when we talk about costs, right, there is a cost to do the planning, right, to kind of put pen to paper, put the thoughts down, get it in a form that's correct, and to execute so you have a deliverable document or set of documents. There are the costs of upkeeping that, right? So that may be, in terms of a revocable trust, that may be making modifications to it as you go along in life and things change for you or the law changes, etc. And then the lion's share of the costs are, what's it going to cost to wind up my affairs after I'm gone? Whether that's a revocable or irrevocable trust. And for most folks, they're not around. Well, all of them. They're not going to be around. It's just, not just most. Actually, all of them.
All of them will
They're not going to be around to see that cost, right? But that's the other cost. I think it's fair to talk about costs.
Right.
But I think when you look at the cost of whether we're doing an irrevocable trust or whether we're doing a revocable trust estate plan, it is insignificant in comparison to the cost, the value of the entire estate.
Yes.
So I talk about cost. We have this discussion with the clients, but really you have to think about what my goals are, because this is a fraction of a percent of the estate.
That's normally my question I receive a lot on the phones, and I say the same thing. Until we know what those goals are, we're shooting in the dark. Without the questionnaire being filled out and returned to the attorney, we can't give you a number. And it doesn't sit well with a lot of people, but I mean, that's honest. I can give you an astronomical number, but we want to be playing fair on even field here. We need that information of what your goals are and what's involved. So.
And I think it's fair to say, because I don't want to be totally elusive about this, that if we're talking trust-based plans, whether it's irrevocable or, I mean, we're talking thousands of dollars, not hundreds of dollars.
Right.
So, so there that is.
Yeah, it's out there. Yeah. Well, that's all the time we have. This was painless.
That's it?
Yeah, that's it. I was a little nervous, but it was painless. We want to thank Andrew for taking the time out of his busy schedule, and it was informative. I learned some things, and I actually enjoyed talking with you.
Who would have thought, Tina? Well, I want to thank the people who tuned in, because it's
absolutely. He was going to definitely thank them as well. If they would like to make an appointment to speak with Andrew Cobin or any of our estate planning attorneys, please give us a call at the number below. It's 919-782-3500, or visit our website at ncestateplanning.com. This event is being recorded and will be posted on our YouTube channel. To be sure not to miss any of our videos there, please subscribe to our YouTube channel as well. We're going to take a little break in December from our YouTube live events, but we'll be back in January, and we'll be interviewing Dan Brady of the Brady Cobin Law Group. So I'm looking forward to that. Get Dan in the hot seat. Well, that's it for us. Thank you again, Andrew, and everyone for joining us. And that's it. We'll talk to you guys later. Thank you.
Bye now.
Bye, guys.